If I asked most people whether their will controls everything they own, many would say yes. That answer is wrong. And the reason it is wrong is not complicated, but it is very important. Estate planning is not mainly about what sounds fair. It is not mainly about what you told your children. It is not mainly about what you wrote in a letter. It is not mainly about what you intended in your mind. Estate planning is about legal structure. Who is in control? When does that control change, and how do assets legally move from one person to another when you are no longer able to speak for yourself? Those are the three questions. If you understand those three questions, wills and trusts become much easier to understand. If you do not understand them, you can spend money on documents that give you a false sense of safety. That is the danger. A lot of people believe that having a will means their estate plan is finished. They believe that when they die, the will simply tells everyone what happens, and that is the end of it. But the legal system does not work that way. Assets move based on legal mechanisms. They do not move based on emotion. They do not move based on family assumptions. They do not move based on what someone says you probably wanted. When someone dies, there is no longer a living person who can clarify intent. So the law looks at the paperwork. How was the asset titled? Was there a contract? Was there a beneficiary designation? Was the asset owned by a trust? If none of those things apply, then the asset may pass through probate and the will can matter. But that is only one bucket. This is the first principle. A will does not control everything. A will controls probate assets. That distinction may sound technical, but it can determine who gets your money, who gets your house, how long your family waits, whether the process is public, and whether your loved ones end up in court during the worst moment of their lives. So let us slow down and go through the machine. There are three primary ways assets move at death. The first way is by contract. Some assets have a contract attached to them. Life insurance is a good example. Retirement accounts are another payable, on-death accounts and transfer. On-death accounts can also work this way. When you name a beneficiary, you are creating a legal instruction inside that account or contract at your death. The contract executes. The money goes directly to the named beneficiary. No court needs to ask what your will says. No judge needs to review whether the will had a different instruction. The beneficiary designation controls. This is one of the most common areas where families are surprised. A will might say, "I leave everything equally to my children." But if your life insurance policy names your brother as beneficiary, that money goes to your brother, the will does not override it. The contract wins. The second way assets transfer is by title. Ownership structure controls many assets. If you own a house jointly with rights of survivorship, the surviving owner may automatically become the full owner when you die. The same can happen with certain joint bank accounts or other jointly titled property. Again, it does not matter what the will says if the title itself has a survivorship feature. The title controls. Imagine someone in a second marriage, they own a house jointly with their current spouse. But their will says they want their share of the house to go to a child from a prior marriage. That person may believe the will has solved the problem. But if the house is titled jointly with rights of survivorship, then at death, the surviving spouse becomes the full owner. The child does not receive that share through the will. No one is ignoring the will. The will simply does not control that asset. The title does. This is how families create outcomes they never intended. Not because anyone was malicious, because the legal structure was misunderstood. The third way assets transfer is by probate. Probate is the court-supervised process for transferring assets at death. Assets that do not pass by contract, do not pass by title, do not have a beneficiary designation, and are not properly owned by a trust may fall into probate. That is the bucket A will controls. So if you hear one sentence from this entire discussion, hear this. A will directs the distribution of probate assets. Not all assets, probate assets. That sentence should change the way people think about estate planning. A will is a revocable legal document. Revocable means you can change it while you are alive and competent. But the will has no legal effect while you are alive. It does not manage your assets. It does not move your assets. It does not help if you become incapacitated. It sits there until death. At death, it becomes relevant only for the assets that fall into probate. A will can do several important things. It can name an executor. The executor is the person responsible for handling the estate through the probate process. They gather assets, they work with the court, they pay final bills, they pay taxes if needed. They distribute what remains according to the will. The executor is the administrator of the estate. A will can also name guardians for minor children. This is extremely important. If you have minor children, the will is the document where you formally state who you would want to raise them if something happened to you. A trust cannot do that. Beneficiary designations cannot do that. Only a will can make that guardianship nomination. The court ultimately has authority, but the will is where your wishes are officially expressed. So if you have minor children, a will is not optional. It is essential. A will can also direct probate assets, but we must be very clear about what a will cannot do. It cannot override beneficiary designations. It cannot override joint ownership with survivorship rights. It cannot avoid probate. In fact, a will is usually the document that begins the probate process. It cannot reduce estate taxes by itself. It does not provide creditor protection. It does not control everything. These limits matter because many people buy a simple will and think they have built a complete system. They may not have. They may have built one piece. Now let us use a simple example. Someone dies with three things: a will that says everything goes to the children, a life insurance policy naming a sibling as beneficiary, a house jointly owned with a spouse. What happens? The life insurance goes to the sibling because the beneficiary form controls. The house goes to the surviving spouse because the title controls. The will controls only whatever probate assets are left. That is the mechanical reality. The legal system follows structure, not assumptions. This is why estate planning has to be done carefully. If the structures do not match the intent, the structures win. Now let us talk about trusts. A trust is not just a document. A trust is a legal relationship. A person who creates the trust, often called the grantor, transfers property to a trustee. The trustee manages that property for the benefit of beneficiaries. That is the structure. A trust separates legal ownership from beneficial ownership. One person may have legal control and management responsibility. Another person may receive the benefit. This separation is the reason trusts exist. It allows you to create rules around how assets are managed when they are distributed. What happens if you become incapacitated? What happens after you die? And how complexity is handled. Trusts are about control, timing, continuity, privacy, and administration. A properly structured and funded revocable living trust can keep assets out of probate. That means the transfer can happen privately instead of inside a public court, supervised process. This is one of the major reasons families use trusts. Probate can be slow, probate can be expensive, probate can become public. A trust can reduce some of that friction if it is built and funded correctly. But that last part is critical. A trust must be funded. Creating a trust document does not automatically move your house, your bank accounts, or your investment accounts into the trust. Assets must be retitled or directed properly. If you create a trust and then leave all your assets in your own name without proper beneficiary or trust ownership structure, those assets may still go through probate. An unfunded trust is mostly paperwork. This is one of the biggest mistakes in estate planning. People pay for a trust, put the binder on a shelf, and never move the assets into it. Then the family discovers after death that the trust did not control the assets it was supposed to control. That is not a trust problem. That is a funding problem. The structure works only if the assets are inside the structure. Now, there are different kinds of trusts. A living trust is created during your lifetime. It can be revocable or irrevocable. A revocable living trust is the most common trust many families consider. While you are alive and competent, you can usually act as your own trustee. You can manage the assets, you can amend the trust, you can revoke it, you can buy and sell in day 2. Day practical life. Very little may change, but legally the structure is in place. If you become incapacitated, your successor trustee can step in and manage the trust assets without waiting for a court to appoint someone. That can be a very powerful feature. Many people think estate planning is only about death. It is not. Estate planning is also about what happens if you are alive but unable to act. Dementia, stroke, severe illness, accident, long-term incapacity. If no structure is in place, your family may have to petition a court for guardianship or conservatorship. That can take time. It can require medical documentation. It can involve hearings. It can cost money. And during that period, the family may be stuck in limbo, unable to access accounts or manage affairs properly. That is not just an inconvenience. It can be a crisis. Bills still arrive, care still has to be arranged, assets still need management, but the family may not yet have legal authority. A revocable trust can reduce this friction for the assets titled to it because the successor trustee is not asking the bank to accept a new power after the crisis. The trustee role already exists inside the legal structure. The successor trustee steps into that role under the terms of the trust, that is continuity. And continuity matters most when life becomes painful. A revocable living trust is also private. Probate is a court process, and court records can become public. The will can be filed, asset information may become visible, distributions may be part of the record. Trust administration is generally private. For some families, privacy matters. For others, it does not matter very much. But it is a real difference. Now, we need to be very careful about what a revocable living trust does not do. A revocable trust does not reduce estate taxes by itself. It does not protect assets from your creditors while you are alive. It does not remove assets from your taxable estate. Why? Because you still control it. Control and taxation are connected. If you create a revocable trust, serve as trustee, retain control, and can revoke the trust, the IRS still treats the assets as yours. That is the basic logic. So a revocable living trust is mainly about administration, continuity, probate avoidance, and privacy. It is not a tax shelter. It is not creditor protection. It is not Medicaid protection. If someone tells you, get a trust to avoid taxes, the first question should be, What kind of trust? A revocable living trust is very different from an irrevocable trust. An irrevocable trust usually means you give up control. Once assets are transferred into it, you generally cannot simply take them back. Because control has been given up, certain irrevocable trusts can sometimes provide estate tax planning, asset protection, Medicaid planning, business succession planning, and advanced wealth transfer strategies. But the trade-off is real. You are no longer in full control. That is why irrevocable trusts are used in more advanced situations and require much more careful planning. For ordinary families, the main comparison is usually between a will and a revocable living trust. That is the conversation most people are really having. A will equals death plus probate plus public. A will activates at death. It works inside the probate court process. Once filed, it may become public. A revocable living trust equals life plus incapacity plus privacy. It can operate during your lifetime. It can provide continuity if you become incapacitated. At death, it can help transfer assets privately if properly funded. That is the mental model. It is not that one is always good and the other is always bad. They solve different problems. A will is simpler. It is usually less expensive to draft. It is easier to maintain. For many straightforward estates, a will may be enough, especially if assets pass mostly by beneficiary designation or joint title and the probate process in that state is not especially burdensome. But a will does not avoid probate. It does not help during incapacity. It becomes public when filed. A revocable trust costs more. It requires more administration. Assets must be retitled. It requires attention over time. But it can avoid probate for funded assets. It can provide continuity during incapacity. It can keep the process more private. The right answer depends on your life. Estate planning should not be driven by a generic checklist. It should be driven by your assets, family structure, state law, priorities, health risks, privacy concerns, property locations, and the complexity of the people involved. Now let us talk more about incapacity planning because it is often overlooked. When someone becomes incapacitated, there are generally 3 routes for another person to step in. The first route is court-appointed guardianship or conservatorship. That means the family asks the court to appoint someone to manage the incapacitated person's affairs. This can work, but it is slow, expensive, public, and stressful. The second route is a durable financial power of attorney. A power of attorney allows someone you name to act on your behalf for financial matters. Every adult should seriously consider having one. It can be extremely useful. But powers of attorney have limitations. Banks and financial institutions may question them. They may reject older forms. They may require their own documents. They may demand review by legal departments. They may accept the power for one account but not another. A power of attorney can help, but it can be uneven in practice. The third route is a successor trustee under a revocable living trust for assets already titled in the trust. The successor trustee can step into a role that already exists. They are not acting merely as your agent. They are acting as trustee under the legal structure of the trust. That can make the transition smoother, but a trust does not replace every other document. A good incapacity plan often includes several pieces. A revocable trust for assets titled to the trust. A durable financial power of attorney for assets outside the trust and other financial matters. A healthcare power of attorney for medical decisions. A living will or advance directive for end of life or treatment preferences. These documents work together. The trust handles trust assets. The financial power of attorney helps with assets and tasks outside the trust. The healthcare documents handle medical decisions. If these documents exist and are coordinated, the family has a path. If they do not exist, the family may end up in court. The goal is to reduce friction during an already difficult time. That is the human purpose of estate planning. Now let us clear up the main myths. The first myth is that trusts avoid taxes. Revocable trusts do not. If you retain control, the assets are still treated as yours. They remain part of your estate for tax purposes. Certain irrevocable trusts may help with taxes, but only because control has been transferred or restricted in very specific ways. So the correct question is never, do trusts avoid taxes? The correct question is, what kind of trust and who controls the assets? Control matters. The second myth is that having a trust automatically avoids probate. Only a properly funded trust can do that. If the trust owns nothing, it controls nothing. If the house was never retitled into the trust, the house may not avoid probate through that trust. If the account was never titled correctly and no beneficiary structure directs it to the trust, it may not avoid probate. The document alone is not magic. Funding is everything. The third myth is that a will controls everything. It does not. A will only controls probate assets, beneficiary designations, joint title, survivorship rights, and trust ownership can all override or bypass the will. The fourth myth is that a testamentary trust avoids probate. A testamentary trust is a trust created inside a will. It does not exist while you are alive. It comes into existence at death through the will. Because it is created through the will, it still goes through probate. So a testamentary trust may provide control after death, especially for minor children or beneficiaries who should not receive assets outright. But it is not a probate avoidance tool. This distinction is important. A testamentary trust can be very useful if you want assets held for a child until a certain age, or if you want staged distributions, or if you want support for health, education, maintenance, and support before full distribution later, but it is born from probate. It does not avoid probate. Now, the guardianship issue deserves special attention. If you have minor children, you need a will. Even if you have a revocable trust, even if most assets avoid probate, even if your financial structure is otherwise organized, the will is where you name the guardian. A trust cannot formally nominate the guardian of your children. This means that for families with minor children, the question is rarely will or trust. It is usually both. The trust may manage assets. The will may name guardians and catch probate assets. A pour-over will is often used with a revocable trust. It says that any assets left outside the trust at death should pour over into the trust, but those assets may still go through probate before they reach the trust, which is why funding the trust during life matters. Again, the structure matters now. Who may not need a trust? Not everyone does. If your estate is simple, if most assets pass through beneficiary designations, if you have no real estate or only simple property, if your family structure is straightforward, if probate in your state is not especially expensive or slow, and if you are comfortable with a durable power of attorney for incapacity planning, a will may be sufficient. This is important because trusts cost more. They require administration. They require retitling assets. They require updating if new assets are acquired. A trust that is not maintained can create confusion. So the decision should not be made because someone on the internet said every adult needs a trust. That is too simple. Every adult should likely have some kind of estate plan, but not every adult needs the same structure. Now, when does a revocable living trust make sense? It makes sense when the structure solves a real problem. If your state's probate process is slow, expensive, or burdensome, a trust may be valuable. If privacy matters to your family, a trust may be valuable. If you own real estate in multiple states, a trust may be very valuable because otherwise your family may face probate in more than one state. If incapacity planning matters and you want a loved one to step in quickly without court involvement for trust assets, a trust may be valuable. If you have a blended family, second marriage, minor beneficiaries, children from a prior marriage, or concerns about beneficiaries receiving money outright, a trust may be valuable. If you want to stagger distributions, set age thresholds, provide for a surviving spouse while protecting children, or manage complexity after death, a trust may be valuable. Trusts shine when complexity exists. They create rules. They create continuity. They create administration outside the public court process, but only if they are drafted well and funded properly. This is why you need qualified legal advice. A badly drafted trust, or a trust that does not match the asset structure, can create false confidence. False confidence is dangerous because people stop looking for weaknesses. Now, let us return to the foundation. Assets move by contract, by title, or by probate. Trust ownership creates another structure that can avoid probate if assets are titled to the trust. A will works only in the probate bucket. A beneficiary designation can beat the will. Joint title can beat the will. Trust ownership can change the administration. This is the operating system. If you understand the operating system, estate planning becomes less mysterious. If you do not understand it, you may think you have done something that you have not done. For example, suppose your will says everything goes equally to your 3 children, but one retirement account still names an ex-spouse. That account may go to the ex-spouse. Suppose your will says your children get your house, but the house is jointly titled with a second spouse with survivorship rights. The spouse may become the full owner. Suppose you create a trust, but the brokerage account is never retitled and has no beneficiary designation. It may go through probate. These are not theoretical problems. They happen because documents are not coordinated. Estate planning is coordination. The will, trust, beneficiary designations, titles, powers of attorney, healthcare documents, and account ownership must all point in the same direction. If they do not, the structure can contradict itself. And when the structure contradicts itself, the law follows the controlling mechanism, not the emotional story. Now, think like a systems person. A person's estate is a collection of assets. Each asset has a transfer rule. You need to identify the transfer rule for each asset. Life insurance, beneficiary designation, retirement account, beneficiary designation, joint account, title, and survivorship. House, deed, and ownership structure, brokerage account, title, TOD designation, trust ownership, or probate bank account, title, POD designation, trust ownership, or probate, personal property, likely probate, unless otherwise structured, business interest, operating agreement, buy-sell agreement, title, trust, or probate. Once you see each asset and its transfer rule, the estate plan becomes concrete. Before that, it is just a stack of documents. This is the practical work. Make an asset inventory for each asset. Ask who owns it. Ask whether there is a beneficiary. Ask whether there is survivorship. Ask whether it is titled to a trust. Ask what happens if you die. Ask what happens if you become incapacitated. Ask whether the result matches your intent. This exercise can reveal problems very quickly. Many estate planning failures are not hidden. They are visible once someone checks the paperwork, but people rarely check they sign documents once, and then life changes, marriage, divorce, second marriage, children, grandchildren, new house, new state, new retirement account, old beneficiary designation, business created, property purchased, parent becomes dependent, child has special needs, family conflict emerges. The old plan may no longer fit. Estate plans must be reviewed periodically. A plan built 10 years ago may not match today's life. And if the paperwork does not match the life, the paperwork wins. Now let us talk about the emotional mistake behind many estate plans. People assume their family will work it out. Sometimes they will, often they will not. Money plus grief plus ambiguity can create conflict. Even good people can disagree when the instructions are unclear. A child may believe they were promised something. A second spouse may believe they should control the house. A sibling may think the beneficiary designation is unfair. A trustee may be accused of mismanagement. A court may become involved. The goal of estate planning is not only to move assets. It is to reduce conflict when emotions are high. Clear structure reduces conflict. Unclear structure invites it. This is why trusts can help in complex families. They allow rules to be written in advance: who receives income, who receives principal, when distributions occur, who manages assets, what happens if a beneficiary is irresponsible, what happens if a child is young, what happens if there is a surviving spouse and children from a prior marriage, what happens if someone becomes disabled, what happens if a beneficiary has creditors. Not all of these problems require a trust, but many can be better managed with one. A will can say who gets what at death. A trust can say how and when assets are used over time. That is the difference. Timing and control. Now, we should also understand the cost side. A will is generally cheaper. A revocable trust generally costs more. But cost should be measured against the problem being solved. If a simple will fit your life, paying for a trust may not add enough value. If your family would face multiple probates, privacy concerns, incapacity risk, and complex distribution needs, the higher cost of a trust may be cheap compared with the friction it prevents. The mistake is choosing based only on cost. The other mistake is choosing the most expensive structure because it sounds more sophisticated. Good planning is fit, not cheapness, not complexity fit. Now, one of the most important lines in estate planning is this: the documents do not matter as much as whether the structure works. You can have a beautiful binder and still have assets titled incorrectly. You can have a simple plan and have everything coordinated perfectly. The plan that works is better. So after creating documents, implementation matters. Retitle the house if appropriate, update beneficiaries, coordinate retirement accounts, confirm TOD or POD designations, name successor trustees, name backup agents, make sure trusted people know where documents are stored, make sure institutions have what they need, review after major life events. This is the unglamorous part. It is also the part that determines whether the plan works. Now, let us consider a revocable trust during incapacity again, because it is one of the most underestimated benefits. If a person becomes incapacitated and their assets are in the trust, the successor trustee can manage them under the rules. They can pay bills, they can manage investments, they can sell property if allowed. They can support the person's care, they can avoid the months of legal limbo that may happen without authority. If the person later recovers, control can return. That flexibility matters. Estate planning should not assume death is the only risk. Long life with declining capacity is often the larger practical risk. Dementia can last years, strokes can impair decision making, illness can create long periods where someone cannot manage finances. In those cases, the goal is not inheritance. The goal is continuity of care. A will does nothing for that. A durable power of attorney may help. A trust can help for trust assets. Healthcare documents help for medical decisions. The complete plan coordinates all of them. That is why the phrase, "I already have a will," is often not enough. The next question is, what happens if you are alive but cannot act? If there is no answer, the plan has a hole. Now let us talk about public versus private. Probate is public because courts are public. Many people do not care. That is fine. But some families do. They may not want asset values, beneficiaries, distribution details, family conflict, or estate information visible in court filings. A trust can keep administration more private for public figures. Business owners, blended families, high conflict families, or anyone who values discretion, privacy can be important. Again, privacy is not about hiding wrongdoing. It is about keeping family financial matters out of the public court record. For some people, that is worth planning for. For others, it is not a priority. The right answer depends on the person. Now, estate taxes. Most families do not owe federal estate tax because the federal exemption is high. But state estate taxes and inheritance taxes may apply in some places. Laws also change. A revocable trust does not solve estate taxes because the assets are still treated as yours. Advanced planning for estate taxes usually involves irrevocable trusts, gifting strategies, charitable planning, business succession planning, and other tools. Those are beyond the simple will versus revocable trust decision. But the key principle is clear. If you control the asset, the tax system generally still treats it as yours. Control equals taxation. To get tax or creditor protection, you often must give up some control. That is the trade-off. People want control and protection at the same time. Sometimes that is possible in limited ways, but often the system requires you to choose. Control has consequences. That is a very Dalio-like principle because it applies across many systems. You cannot keep all the upside, all the control, all the flexibility, and all the protection without trade-offs. Estate planning is trade-offs. Now, irrevocable trusts. They can be useful for long-term care planning, asset protection, Medicaid planning, large estates, business succession, and advanced wealth transfer. But they are not everyday tools to be used casually. Giving up control is serious. If the trust is irrevocable, you may not be able to change your mind easily. You may not be able to access the assets. You may need independent trustees. You may have tax filing obligations. You may create family complexity. So do not use an irrevocable trust because it sounds stronger. Use it only when the problem it solves is real and the trade-off is acceptable. This is why professional advice matters. Now, let us return to a very practical question. If someone is deciding between a will and a revocable living trust, what should they ask? First, what assets do I own? Second, how is each asset titled? Third, which assets already have beneficiary designations? Fourth, which assets would go through probate if I died today? Fifth, is probate in my state slow, expensive, or simple? Sixth, do I own real estate in more than one state? Seventh, do I care about privacy? Eighth, do I have minor children? Ninth, do I have a blended family or second marriage? 10th, do I want distributions controlled over time? 11th, what happens if I become incapacitated? 12th, do I need tax planning, creditor protection, Medicaid planning, or just administrative continuity? Those questions lead to the structure. Without those questions, people choose documents blindly. A document is not a plan. A plan is the structure created to solve specific problems. Now, I want to explain why beneficiary designations are so powerful. They are simple, but they can override everything else. A retirement account beneficiary form can direct a large part of someone's wealth. If it is outdated, the wrong person can receive the money. A divorced person may forget to update a life insurance policy. A parent may have named one child long ago and never revised the form after more children were born. A person may name minor children directly, creating court involvement or custodial complications. A beneficiary may die before the account owner, and no contingent beneficiary may be listed. These are common problems. Updating beneficiary designations is one of the simplest and most important estate planning actions. It should be reviewed after marriage, divorce, birth, death, major asset changes, and any significant family change. The will cannot fix everything later. The beneficiary form wins. This is the mechanical truth. Now, joint ownership. Joint ownership can be useful, but it can also create unintended consequences. Adding a child to a bank account may allow them to help pay bills, but it may also make them full owner at death or expose the account to that child. As creditors, adding someone to a deed may create gift tax issues, loss of control, capital gains complications, creditor exposure, or family conflict. Joint ownership is not a simple estate plan. It is a transfer of legal rights that should not be done casually. The right structure may be a power of attorney, trust, beneficiary designation, or other tool instead of joint ownership. Again, the mechanism matters. Now, let us think about probate. Probate is not always terrible. In some states, probate is manageable, quick, and not too expensive. In others, it can be slow, costly, and burdensome. Some families do not mind court involvement. Some families would strongly prefer to avoid it. So avoiding probate is not automatically the most important goal for everyone. But people should make an informed decision. If probate is acceptable, a will may be enough. If probate would create delay, public exposure, multiple state complications, or family conflict, a trust may be worth considering. The issue is not that probate is evil. The issue is whether probate fits your family's needs. Now, for families with minor children, the trust can manage inheritance, but the will names guardians. This is a crucial pairing. Suppose both parents pass away and leave life insurance to minor children. If there is no trust structure, a court may need to appoint someone to manage the assets until the children reach legal age. Then the children may receive a large amount outright at 18 or 21. Depending on the jurisdiction and structure, many parents would not want that. A trust can say the money is used for health, education, maintenance, and support, and then distributed later at age 25, 30, or in stages. That kind of control can protect children from receiving too much too soon. A will can create a testamentary trust for that purpose, but it goes through probate. A revocable trust can create a similar structure outside probate if properly funded and coordinated. This is a classic reason families use trusts, not because they are rich, because they have children and want continuity. Now, blended families, this is another area where simple wills can fail to reflect the real risk. A person may want to provide for a surviving spouse, but also preserve assets for children from a prior marriage. If everything is left outright to the surviving spouse, the children may receive nothing later if the spouse changes their plan, remarries, spends the assets, or leaves them to different beneficiaries. A trust can create rules. It can provide income or support for the spouse while preserving principal for children later. This is more complex, but complexity may be necessary when the family situation is complex. A simple plan in a complex family can create injustice. The structure must match the reality. Now, the same applies to beneficiaries who are financially irresponsible, vulnerable, disabled, dealing with addiction, in unstable marriages, or exposed to creditors. Leaving money outright may not be wise. A trust can provide management, staged distributions, or protections. Again, the purpose is not control for the sake of control. The purpose is to make the inheritance useful rather than destructive. Money without structure can create problems. Trust can create structure. Now, do not misunderstand. Trust can also create conflict if badly drafted, if the trustee is the wrong person, or if the rules are unclear. The trustee role is powerful. The trustee must be competent, honest, organized, and able to follow fiduciary duties. Naming the wrong trustee can create enormous problems. So if you create a trust, choose trustees carefully, name backups. Consider whether a professional trustee may be appropriate. Think about family dynamics. Do not choose someone simply because they are the oldest child. Choose based on competence and trustworthiness. A good trustee can make the plan work. A bad trustee can create conflict. Now, if you already have a will or trust, the question is not only whether you have the document, ask whether it still matches your life. Are the beneficiaries current? Are the trustees still appropriate? Are the executors still alive and willing? Are children now adults? Has the estate grown? Have you moved states? Have tax laws changed? Have family relationships changed? Has a beneficiary developed creditor, addiction, disability, or marital issues? Have you acquired real estate in another state? Have accounts been retitled? Has the trust been funded? These are review questions. A stale estate plan can be almost as dangerous as no plan. Now, I want to reduce this entire topic to a few principles. First, legal structure controls asset movement. Not your feelings, not vague intention, the structure. Second, assets generally move by contract, title, trust ownership, or probate. You must know which mechanism applies to each asset. Third, a will only controls probate assets. It does not override beneficiary forms or joint ownership. Fourth, a will is essential for naming guardians for minor children. Fifth, a revocable living trust can help avoid probate, preserve privacy, and manage incapacity, but only if properly funded. Sixth, revocable trusts do not reduce estate taxes or provide creditor protection because you retain control. Seventh, irrevocable trusts may provide advanced benefits, but they require giving up control and should be used carefully. Eighth, incapacity planning requires more than a will. You need powers of attorney, healthcare documents, and possibly a trust. Ninth, the plan must be coordinated. Documents, titles, and beneficiary designations must all match. 10th, the right plan depends on your life, not on someone else's checklist. These principles matter more than labels. Now, I want to end with the deeper purpose. Estate planning is not about documents. It is about making one of the hardest moments in life less painful for the people you love. When someone dies or becomes incapacitated, the family is already under emotional stress. The plan should not add confusion. Court delay, public exposure, frozen accounts, or conflict on top of grief. A good estate plan reduces friction. It gives authority to the right people. It moves assets according to structure. It protects children. It creates continuity during incapacity. It preserves privacy where needed. It avoids unnecessary court involvement where appropriate. It reduces the chance that family members fight because the plan was vague. That is the point. Not a binder, not a document title, a functioning system. If you take this seriously, start with your asset inventory, then check the transfer mechanism for each asset, then review your will, then review beneficiary designations, then review titling, then consider whether a revocable trust solves real problems for you, then make sure incapacity documents exist, then get qualified legal advice in your state, then implement the plan properly. The implementation is where many people fail. A trust not funded is not enough. A will with outdated beneficiaries is not enough. A power of attorney no institution will accept may not be enough. A guardian not named for minor children is not enough. An estate plan is only good if it works when your family needs it. That is the standard, not whether it looks complete. whether it works. And the way to make it work is to understand the structure before the crisis arrives. Because after the crisis arrives, the law will not ask what you wish you had done. It will follow the paperwork that exists. That is why planning now matters. The documents are not for you alone. They are for the people who will have to act when you cannot. Do not leave them guessing. Do not leave them in court unnecessarily. Do not assume the will controls everything. It does not. Build the structure while you can still choose. That is the responsible thing to do.